Okay folks, let's get started. Now, one of the basic structural features of criminal law in the United States is that we normally are looking for culpability before we can call it a crime. As the Supreme Court put it in Morissette versus United States back in 1952, a famous strict liability case, the court said, criminal liability requires both an evil-meaning mind and an evil-doing hand. We take it even one step further than that in many settings in the criminal law. We go beyond asking the yes-no question, is this actor culpable in some way? We ask more specifically, what type of culpability is involved? Now, we try to attach to each of the objective elements of the crime some kind of culpability. So for every act, for every result, for every attendant circumstance that would be the objective elements of the crime, we attach a state of mind to each of those. It's a hierarchy. There's the top level, the most serious, and we work our way down to less serious culpability levels. So in this video topic, we're going to look through the basic definitions of the different levels of culpability in American criminal law, both the old common law terminology and then focusing on the Model Penal Code collection of those culpability levels. So by the end of this video, you should be able both to read a news account and be able to think what level of culpability is likely involved for that actor, or you should be able to read an old statute that uses some language that is not Model Penal Code language, and you should be able to translate it into Model Penal Code-ese, that is the language of the Model Penal Code. You should be able to map old language onto the new scheme of the Model Penal Code. So let's jump in. Now, there are old statutes and old cases that use a whole vocabulary, a whole dictionary of culpability words, different words that you use to describe the blameworthy state of mind that you need to have a crime. Those words, they might include intentionally. Sometimes you hear them talking about feloniously doing this or that act. It might be that you have to do the act maliciously or wantonly or willfully. One of my favorites comes from the law of homicide, where the courts talk about an abandoned and malignant heart. Various colorful, poetical phrases to describe culpability. What we have in the Model Penal Code is an effort to systematize this, to pull all these words together, to give them some kind of consistent meaning, and to place them into some kind of hierarchy. So we're going to step through the 4 levels of culpability, 5 if you count strict liability, and get a sense of what each of those mean. So let's start moving through the Model Penal Code categories. So we'll start at the top of the scale, purposefully. The Model Penal Code, as you see the provision here, says that a person acts purposefully if it's their conscious object to create a result or to engage in a certain kind of conduct. There's also an interesting sidebar here dealing with attendant circumstances elements. We'll deal with that later. For now, focus on the conscious object to engage in the conduct or to produce the result. So let me give you an example. Let's suppose that I want to destroy my competitor's business. And so I know that they're sending their key employee to a meeting, a make or break meeting. The person's coming by train. I want to stop that train. I plant a bomb. It's going to blow up. Sure enough, the bomb blows up, and the employee misses the meeting, and lots of loss results. I can be charged with purposeful destruction of property, both the destruction of the railroad's property and the destruction of my business competitor's property. And I can do that because, that's my conscious desire, because it is my purpose to bring about that destruction of property. Now we move to the second level of culpability, one down from purposefully, and that's knowingly. Under the Model Penal Code, here we're talking about somebody who's aware that they're performing the conduct, or they're aware of the attendant circumstances that would be the objective element, or they're aware that the result is practically certain to happen. It's those two concepts together that matter here, the awareness and the certainty. I know that it's going to happen, or at least I'm practically certain. I'm 95% certain that this is going to happen. So if you compare this to purposefully, well, with purposefully, what you've got is somebody wanting an outcome. For knowingly, you take away the desire, but you still are doing it and you know it's going to happen. You have something approaching certainty. Let's return to our train example. Let's suppose that I intentionally time the explosion so that it happens just as the train is crossing a bridge over a huge gorge. I want to make sure that that train is very late. I don't want anyone to die, but I'm almost sure that anybody on the train is going to die. In this situation, I'm guilty, first of all, of purposefully causing the destruction of property, but I'm also guilty of knowingly causing the death of human beings. It's not my desire, but it is something that I'm virtually certain will happen when you blow up the bridge and the train plunges thousands of feet into the canyon below. Now, there's a special application of the knowledge level of culpability, sometimes called deliberate ignorance or willful blindness, also sometimes called the ostrich defense. And in most places it doesn't work, this ostrich defense, because we interpret the knowledge requirement to say that if you don't know something, but you have arranged the world so that you're not going to learn this thing, then that counts the same as knowledge. So an example, if I'm running a company and I'm running a food company and we distribute food that is contaminated, it's making people sick, but I arrange things so that I don't ever learn about the contamination. The head of production, the director of production, reports to the vice president instead of to me, and I don't ever want to hear those reports. If I've arranged the world so that I'm not going to hear about the critical information about contamination, I could still be prosecuted for knowingly distributing contaminated food because I am an ostrich, because I am deliberately ignorant about the critical facts. So a special application of the knowledge level. Okay, now the next level of culpability, moving one level down, recklessly. As the Model Penal Code suggests here, a person is going to act recklessly if that person consciously disregards, notice the phrase here, a substantial and unjustifiable risk that the material element exists or will result. But the idea here is a conscious disregard of risk. That's the key element here. Notice that the risk is linked to this gross deviation concept. The risk has to be well out of bounds for normal conduct. It's got to be a gross deviation from what we normally expect of people. So if you compare recklessly to the other levels of culpability, you move from purposefully down to knowingly when you lose the desire. You move from knowingly down to recklessly when you lose the certainty. So knowingly has to be what, 95, 100% certain that it's going to happen. Recklessly you can be, somewhat less certain. So back to our train example, let's suppose now that I am going to set the bomb to go off at some random point on the journey to the site of the meeting. I know that there are bridges going over gorges at various points along the way, but I don't know when exactly the bomb's going to go off. I know there's some risk that it's going to go off at a moment when the train is on a bridge and the train will plunge down into the gorge. I'm willing to take that risk because I really want to wipe out this competitor. So I set the bomb. The train leaves the station, and sure enough, the bomb goes off over the bridge over one of these gorges. I can be charged with recklessly causing the death of another human being, because even though I wasn't certain that the train would plunge down into a gorge, I took a substantial and unjustifiable risk that it would do so. And then finally, there's the negligent level. This is the fourth of our levels, and it's the least demanding. Notice here that instead of asking what is actually going on in the mind of this defendant, we ask what should be going on in the mind of the defendant. So we ask, should this defendant be aware of a substantial and unjustifiable risk? And what kind of risk is that? Well, it's got to be a gross deviation from the standard of care. We're not talking about ordinary tort negligence here. We're talking about what you would call in tort law gross negligence. It's got to be something very clearly beyond what we would expect of people. But the key idea is that the other levels of culpability, the purposeful level, the knowing level, and the reckless level, those are all subjective standards. That is, we're asking what is going on inside the subjective mind of that defendant. Whereas with negligence, it's an objective standard, and so we stand outside the person, and we don't ask what really was going on inside the mind. We ask what should have been going on inside the mind. So for our example, let's imagine that I am not thinking at all about the route of the train. I'm not even aware that the train passes over bridges that go over gorges. I know I'm going to put a bomb on the train. I know I want to set the bomb off along the way to stop the train and stop my competitor from attending the meeting. But I just haven't thought at all about the bridges or the risk of death to the people on the train. If the jury believes that, he never even thought about it, they can nevertheless convict me of negligently causing the death of another human being because I should have been aware of the risk of the train going down into one of those gorges when the bomb went off on the bridge. Now, we've talked about 4 different levels under the Model Penal Code. So purposeful, knowingly, recklessly, negligently. There's also, down at the bottom, strict liability. That's a topic for another day. We won't deal with that now. I just want to flag for you that there is a 5th potential element, but it's highly disfavored under the Model Penal Code and really at common law as well. Finally, let me mention to you that there is another way that older common law cases talk about the different levels of intent or the types of culpability that are necessary to establish a crime, and that is the old distinction between general intent crimes and specific intent crimes. Let me just right now, on behalf of centuries of common law lawyers, profoundly apologize to you newcomers. We are so sorry. This is a terrible distinction, and it causes a lot more confusion than it's worth. Nevertheless, it shows up in the case law. Sometimes it shows up in the statutory codes. We got to deal with it, and we'll deal with it over the course of the semester. So we'll do the best we can, but I need to flag for you that this is a very unsatisfying, unstable way of describing the level of mens rea required. But here's one way to think about it. Sometimes when you read the cases, it sounds like specific intent is being used to describe what the Model Penal Code would call purposeful conduct or intentional conduct. And then general intent, that phrase, is used to describe anything below that, whether it would be the knowing or the reckless or the negligent levels of intent. So sometimes that's what courts mean. At other times, they mean something a little different, and it's best illustrated with burglary. So let's suppose I'm a burglar. I've come to the window. I raise the window sash. As I am stepping into the structure, the home, the place of business, whatever is required under the burglary statute, I have now committed a breaking and entering. I am entering the structure. If I do so with the intent to commit a felony inside, then it's burglary. So notice with burglary, what we're interested in is not only what you're doing now and the fact that you're doing it intentionally, you're aware that you're stepping through a window that you're breaking and entering, but there's something additional that you're planning. You have some idea of what the next thing will be. So sometimes courts refer to specific intent as a way of describing that state of mind that says you know what you're doing now and you know that it's leading to some other result or further action. Whereas assault is kind of the classic general intent crime, because when you swing and miss, that would be an assault, or when you swing and connect, a battery, we don't ask, are you aware of the reaction that you're likely to get from your victim or the damage that you're likely to cause to your victim? We're not interested in that. We just ask, are you aware that you're swinging at a person? Are you aware that you're aiming for some kind of offensive conduct? The bottom line on general intent and specific intent is this. You have to be aware of the case law and the statutory code in the jurisdiction where you're working, and you will learn that there's a list of crimes that have been called general intent crimes and a list of crimes that over time have been labeled specific intent crimes. And you just have to know what's on the list, even though the rationale for how they got there might be a little shaky or a little confusing. All right, so we're going to be practicing with these concepts when we next get together. And what I want you to be able to do is look at any given set of conduct and talk about which level of culpability the prosecution might be able to prove based on those facts. See you soon.